Sexually dangerous predator. For more than a decade, the state of Georgia has had a system to monitor these offenders after their sentence is finished.
But now the Georgia Supreme Court says it's unconstitutional. WSAV's Joanne Merrigan talked with Chatham County prosecutors today about the ruling.
District Attorney Meg Heap says the ruling is a big concern and that across the state there are prosecutors who still believe the whereabouts of these offenders needs to be monitored 24 hours a day. That's because this group has been classified as high risk for reoffending.
It's disturbing that the most dangerous sex offenders in the state of Georgia who are off sentence are now going to be free to roam anywhere they want without any way to monitor them.
That sums up the concerns of the Chatham County DA's office.
The Supreme Court ruled that, once your sentence is through, it's unconstitutional. So something needs to be put in place to monitor these individuals.
Many have heard of the state sex offender registry. Someone convicted of a sex crime must register and stay away from certain places like schools. But there have been additional rules for someone classified as a sexually dangerous predator likely to reoffend, especially in a crime against children. Those offenders have been required to wear an electronic monitoring device for the rest of their lives, even after their sentence is up.
Well, each of these sex offenders knows that they're being monitored, and I think that acts as a deterrent, so they don't go to places that they shouldn't go to.
Assistant Chief District Attorney Greg McConnell and District Attorney Meg Heap believe these offenders have not committed new crimes in Chatham County because of the fact they have been monitored 24 hours a day.
That monitor is gone, so if somebody goes to somewhere else, you can't track them.
In Chatham County, there are now 17 offenders classified as sexually dangerous predators that are not in custody. They have been monitored by the sheriff's office. But the Supreme Court says the constant monitoring after someone's sentence is finished constitutes an unreasonable search.
This needs to be changed through new law.
Heap says that she's already contacted other district attorneys so all can appeal to lawmakers. She says offenders will still be registered with the state, but that the constant electronic monitoring of their whereabouts is likely to end, maybe within days. Heap says authorities are evaluating the local situation with the monitors right now. Meanwhile, she's hoping for a new law that will hold up with the state Supreme Court, one that spells out lifetime monitoring of this class of sexual offender that should be required even after the sentence is finished and they're no longer on parole or probation. Joanne Merrigan, WSAV News 3.